The Bush faith-based initiative blithely discarded a key part of this rule, permitting religious groups to take tax funds yet reject job applicants with the wrong views about religion. Americans realize that this is fundamentally unfair. Bush's plan drew support from the religious right and a few conservative denominational leaders who insisted that religious organizations should be able to take public funds while engaging in job bias. But opponents mobilized as well. Religious civil liberties and civil rights and social service advocacy groups came together to address the issues of hiring bias and proselytism with public funds. They formed the Coalition Against Religious Discrimination, CARD, to educate the American people about these issues and lobby Congress for appropriate legal safeguards. If a religious group doing social service wants to receive funds, which many of us in the secular community believe is completely unconstitutional, then at least it should be made clear and enforced that no evangelism or worship will be allowed in publicly funded programs. Houses of worship should be required to set up separate, nonprofit 501c3 organizations to administer those funds from the government. Finally, religious groups accepting governmental grants must agree to abide by the nation's civil rights laws and give up the right to hire and fire on the basis of religious belief. During the 2008 campaign, then-candidate Obama expressed many of the same concerns. In a speech in Zanesville, Ohio, Obama said, "If you get a federal grant, you can't use that grant money to proselytize to the people you help, and you can't discriminate against them or the people you hire on the basis of their religion." The Obama administration has increased the amount of funds to faith-based programs. When the new President Obama rolled out his version of the faith-based initiative in February 2009, he left the old Bush executive orders in place. He renamed it the White House Office of Faith-Based and Neighborhood Partnerships. Joshua Dubois, called Obama's pastor-in-chief, is the head. He is a Pentecostal minister. That means billions in federal funds are being dispersed without much-needed safeguards. Administration officials have indicated that discrimination claims will be looked at on a case-by-case basis instead of being barred by government-wide action. In November 2010, Obama issued an executive order making a few changes to the faith-based initiative, but leaving the discriminatory hiring policy intact. Americans who support civil rights and civil liberties are calling on Obama to keep his commitment. There is an interesting case that the Obama administration has engaged in recently, which is still pending. Unfortunately, the right of religious employers such as churches and related institutions to require that employees be of the same religion as their employer and to follow that religion's dictates is not an issue in this case, but it is an extremely important case all the same. Hosanna Tabor Evangelical School is a small, church-run evangelical Lutheran school in suburban Detroit. Its former fourth grade teacher, Cheryl Perrick, was hired to teach an academic curriculum, but she was also hired to teach her students religion classes, lead class prayer, lead scriptural devotionals, attend school-wide chapel services with her class, infuse religion into secular subjects she taught, and be a good Christian role model to her students. In short, her job was to instill the Lutheran faith in the next generation in her classroom. During one summer recess, Perrick fell ill and took an extended leave of absence. After seeking to accommodate her absence, it says the church eventually hired a replacement. A number of Christian denominations, including the Lutheran Church, have long taught that Christians should resolve religious-related disputes within the church rather than sue each other in secular civil courts. They claim this teaching comes directly from the Bible, 1 Corinthians chapter 6. Here is the passage. "Dare any of you, having a matter against another, go to law before the unrighteous and not before the saints? Do you not know that the saints will judge the world? And if the world will be judged by you, are you unworthy to judge the smallest matters? Do you not know that we shall judge angels? How much more things that pertain to this life? If then you have judgment concerning things pertaining to this life, do you appoint those who are least esteemed by the church to judge? I say this to your shame. Is it so that there is not a wise man among you, not even one who will be able to judge between his brethren? But brother goes to law against brother, and that before unbelievers. So, when Perrick threatened to take the church to court instead, she did so, the church believes, contrary to church teaching. The church released Perrick from her call as what it describes as a commissioned minister and teacher for insubordination and disruptive conduct in violation of church teachings. Perrick claims the school retaliated against her for filing a discrimination claim with the government, the Equal Employment Opportunity Commission, EEOC. She wants the court to reinstate her as a teacher of the school, at the school, over the objections of the church that runs the school. The church argues that her lawsuit cannot proceed because she was a ministerial employee. The trial court ruled in the church's favor, but the appeals court sided with Perrick, reasoning that she did not teach enough religion amid the secular subjects during the school day to be deemed a minister. Indeed, the ministerial exception, as it is called, and the constitutional protection afforded by it, allows churches to lawfully select leaders and the authorized bearers of their messages based on their sincerely held religious beliefs. Catholics and Orthodox Jews can have an all-male clergy. Jews, Muslims, and Hindus can base leadership decisions on ethnicity and descent. And where marital status discrimination is prohibited, churches can discriminate based on celibacy. So, if the ministerial exception did not exist, the landscape of religious life in our country would likely be vastly different. Most of the experts agree that this is an arcane but very important case. As of October 5th, 2011, there is cautious optimism about the case because of the way the Supreme Court handled it during our oral arguments in the Hosanna Tabor Evangelical Lutheran Church and School versus the EEOC et al. Case. Bill Burgess, attorney and legal coordinator of the American Humanist Association's legal arm, the Appignani Humanist Legal Center, said, "The Supreme Court has in past rulings made clear that the free exercise clause of the Constitution does not give religious defendants a special right to violate any law that they feel infringes in some way on their freedom of religion.